Today let's read about administrative and legislative reforms after 1857. Government of India Act 1858. British Crown decided to assume sovereignty over India from the East India Company in an apparent consequence of the revolt of 1857, described as an armed sepoy mutiny by the British historians and remembered as the first war of independence by the Indians. The first statute for the governance of India under the direct rule of the British government was the Government of India Act 1858. It provided for absolute British imperial control over India without any popular participation in the administration of the country. The powers of the Crown were to be exercised by the Secretary of State for India, assisted by a council of 15 members known as the Council of India. The country was divided into provinces headed by a governor or lieutenant governor aided by his executive council. The provincial government has to function under the superintendence, direction, and control of the Governor General in all matters. All the authority for the governance of India was vested in the Governor General in Council, who was responsible to the Secretary of State. The Secretary of State was ultimately responsible to the British Parliament. Indian Council Act 1861. This is an important landmark in the constitutional history of India. By this act, the powers of the Crown were to be exercised by the Secretary of State for India, assisted by a council of 15 members, known as the Council of India. The Secretary of State, who was responsible to the British Parliament, governed India through the Governor General, assisted by an Executive Council. This act enabled the Governor General to associate representatives of the Indian people with the work of legislation by nominating them to his expanded council. This act provided that the Governor General's Executive Council should include certain additional non-official members also while transacting legislative business as a legislative council. But this legislative council was neither representative nor deliberative in any sense. It decentralized the legislative powers of the Governor General's Council and vested them in the governments of Bombay and Madras. Indian Council Act 1892. The non-official members of the Indian Legislative Council were to be nominated by the Bengal Chamber of Commerce and the provincial legislative councils, while the non-official members of the provincial councils were to be nominated by certain local bodies, such as universities, district boards, municipalities, jamindars, etc. The council were to have the power of discussing the budget and addressing questions to the executive. Parliamentary reforms and the Indian Council Act 1909. Reforms recommended by the then Secretary of State for India Lord Morley and Viceroy Lord Minto were implemented and the Indian Council in the Indian Council Act 1909. The maximum number of additional members of Indian Legislative Council, the Governor General's Council, was raised from 16 under the Act of 1892 to 60, excluding the executive councillors. It provided for the first time for the association of Indians with the executive councils of Viceroy and governors. Satyaprasad Sinha became the first Indian to join the Viceroy's executive council. He was appointed as the law member. It also provided for the separate representation of Presidency Corporation, Chamber of Commerce, universities, Jamindars, Sikhs, Indian Christians, Anglo-Indians and Europeans. The size of provincial legislative council was enlarged by including elected non-official members so that official majority was gone. An element of election was also introduced in the legislative council at the center also, but here the official majority was maintained. The legislative councils were empowered to move resolutions on the budget and on any matter of public interest, except certain specified subjects such as the armed force, foreign affairs, and the Indian states. It provided for the first time for separate representation of the Muslim community, and thus the act legalized communalism. And Lord Minto came to be known as the father of communal electorate. The Government of Indian Act 1915. This act was passed to consolidate the provisions of the preceding Government of India Acts, Montagu Chelmsford Reforms and the Government of India Act 1919. The then Secretary State for India, Mr. E.S. Montagu, and the Governor General, Lord Chelmsford, formulated proposals for the Government of India Act 1919. It created a new office of the High Commissioner for India in London and transferred to him some of the functions hitherto performed by the Secretary of State for India. It provided for the establishment of a public service commission. Hence, a central public service commission was set up in 1926 for recruiting civil servants. Responsible government in the provinces was to be introduced without impairing the responsibility of the governor through the governor general for the administration of the province by resorting to device known as diarchy or dual government. This act provided voting right to the Indian women for the first time. David Lloyd George was the then Prime Minister of England. The subjects of administration were to be divided into two categories, central and provincial. Central subjects were those which were exclusively kept under the control of the central government. The provincial subjects were subdivided into transferred and reserved subjects. The transferred subjects were to be administered by the governor with the aid of ministers responsible to the legislative council, in which the proportion of elected members were raised to 70%. The reserved subjects were to be administered by the governor and his executive council with no responsibility to the legislatures. The previous central control over the provinces in administrative, legislative, and financial matters was relaxed. Sources of revenue were divided into two categories so that the provinces could run the administration with the revenue raised by the provinces themselves. The provincial budget was separated from the central budget. The provincial legislature was empowered to present its own budget and levy its own taxes relating to the provincial sources of revenue. The central legislature retained power to legislate for the whole country on any subject. The control of the Governor General over provincial legislation was retained by providing that a provincial bill, even though assented to by the Governor, would become law only when assented to also by the Governor General. The Governor was empowered to reserve a bill for the consideration of the Governor General if it was related to some specific matters. The Governor General and Council continued to remain responsible only to the British Parliament through the Secretary of State for India. The Indian legislature was made more representative and for the first time bicameral. Lionel Curtis was a British officer and author. His ideas concerning diarchy were important in developments of Government of India Act 1919 and his writing influenced the evolution of the Commonwealth of Nations. The upper house was named the Council of State. This was composed of 60 members, of whom 34 were elected. The lower house was named the Legislative Assembly. This was composed of about 144 members, of whom 104 were elected. The electorates were arranged on a communal and sectional basis, developing the mollem into device further. The Governor General's overriding powers in respect of central legislation were retained as follows. His prior sanction was required to introduce bills relating to certain matters. He had the power to veto or reserve the consideration of the Crown any bill passed by the Indian legislature. He had the converse power of certifying bill or any grant refused by the legislature. He could make ordinances in case of emergency. Then comes Simon Commission. This commission, headed by Sir John Simon, constituted in 1927 to inquire into the working of the Act of 1919, placed its report in 1930. The report was examined by the British government, British Parliament, and the Government of India. Bill was drafted accordingly.